Hello friends, I'm Dr. Anthony Raju, Advocate Supreme Court, and today we will be talking about a landmark Supreme Court judgment that held that viewing, possession and storage of material depicting minors engaged in sexual activity is an offense. The judgment was delivered on the 23rd of September by a division bench of Chief Justice D.Y. Chandrachud Sahab and Justice J.B. Pardiwala in a case titled Just Right for Children Alliance versus S. Harish. The decision brings closure to a long-standing split among High Court on whether mere storage of child pornography can be considered an offence under Section 50 of the Protection of Children from Sexual Offences POCSO Act 2012 and Section 67B of the Information Technology Act 2000. With this decision, India joins an exclusive club of countries that have explicitly criminalized watching child pornographic material. The judgment overturned the Madras High Court decision in S. Harish versus Inspector of Police and another, which had quashed criminal proceedings against a POCSO accused Harish after finding out that downloading or watching child pornography was not per se penalized under POCSO or the IT Act. First, we look at Section 50, subsection 1 of the POCSO Act. This states that any person who stores or possesses child pornography and fails to delete, destroy, or report it can be punished with a fine up to 5,000 upon a second offence, and the fine increases to 10,000. Section 15, Clause 2 states that if possessions and storage are with the intent, see, we are talking about the intent of transmitting, propagating, displaying, or distributing, then there may be a higher punishment of up to 3 years of imprisonment. Many high courts have interpreted this to mean that the intent to distribute or commercially use such content was essential for storage and possession to be considered an offense. Ladies and gentlemen, now let's move on. The Information Technology Act, Section 67B of the Act, penalize the publishing and transmitting of child pornography. So how did the Madras High Court interpret these provisions to ultimately quash criminal proceedings against the POCSO accused? On the 29th of January 2020, a cyber tipline report from the National Crime Record Bureau informed Tamil Nadu Police that one S. Harish had been an active consumer of child pornography and FIR was registered under the POCSO Act. When Harish's phone was analyzed by the Forensic Science Lab, 2 child pornography videos were discovered. These videos had been recorded locally in Tamil Nadu. An investigation revealed that these were of the children who had been missing from some time. In September 2023, a charge sheet was filed against Harish under Section 15, subsection 1 of the POCSO Act and Section 67B of the IT Act. When Harish approached the Madras High Court to catch the criminal proceeding in January 2024, the High Court held that mere possession or storage was not an offence. It ruled that Harish was not guilty under Section 67B of the IT Act either. An NGO called Just Right for Children Alliance appealed this decision of February 2024. They argued that as the judgment was widely covered by news outlets, it would create the impression among the general public and downloading and possessing child pornography is not an offence. This, they claimed, would increase demand for child pornography and encourage people to involve innocent children in it. On the 11th March, while hearing the appeal, the Chief Justice remarked that High Court judgment was atrocious. Justice Pardiwala, who authored the judgment, clearly outlined the scope of the Section 50 of the POCSO Act. He stated that Section 50 provides for 3 distinct offences that penalize either storage or possession of child pornography materials depending on 3 separate intentions. Each intention, as he claimed, was addressed in each subsection of Section 15. Now, Section 15, subsection 1 penalized the failure to delete, destroy, or report child pornography in the possession of an accused person. Clause 2 penalized the actual transmission, propagations, display, or distribution of such materials. Clause 3 penalized the storage or possession of child pornographic material when done with a commercial intent. So now we are talking the commercial intent. Justice Pardiwala explained that under Section 50, Clause 1, particularly mens rea intent is to be gathered from actus rea action of possessing the material but not reporting. Each case would require looking into the facts and circumstances of how possessions came about and why no disclosure was made. By this interpretation, mere possession of child pornography, unless deleted, destroyed, or reported by the accused, is an offence under the POCSO Act. Justice Pardiwala also clarified that each provision of Section 15 is independent of the others, which put an end to the alternative interpretation that High Courts had developed, reading these separate instances of possession and distribution as making up a single offence. Section 30 of the POCSO Act states that any POCSO offence, the special court shall presume that the accused has a culpable mental state. If foundational facts are established prima facie, the burden is on the accused to show that they are not guilty. For example, in the case, the prosecution only has to show the foundational fact that the accused was in possession of child pornography and did nothing to get rid of it or report it. The burden lies on the accused to establish their innocence. The High Court noted that presumption of culpable mental state is a factor that High Court should consider when deciding whether cases should be quashed. Justice Pardiwala wrote that High Court must slow, circumspect, and exercise restraint in deciding whether a POCSO case should be quashed. While interpreting Section 67B of the IT Act, the court clarified that Section 67B does not only ban electronic disseminations as per the Madras High Court interpretation but also criminalize the possession and consumption of child pornography. Justice Pardiwala suggested in the way we speak about child pornography, particularly in the legal sense. The court observed that in cases of child pornography, the victimization of the minor starts with the sexual act but continues with the recording and perpetuations of the photos and videos creating ripple of trauma. He suggested that the term child sexual exploitative and abuse material was more appropriate than he wrote that child pornography the victimization because the term a conduct that may be legal and involves voluntary participation. The judgment Parliament to consider amending the POCSO Act to substitute child pornography with CSEAM. It also directed all courts to stop using the term child pornography in judicial order and judgment. Noting that social media intermediaries play a significant role in the dissemination of child pornography, the court outlined the obligation to report the publication and the circulation of such content under various laws, and obligation intermediaries have so ignored. The judgment reiterated Section 19 and 20 of the POCSO Act, which impose an obligation on persons, media, hotel staff, hospital staff, clubs and studios to report any child pornography materials. Section 21 states that failing to do so would result in imprisonment of up to 6 months. The court also made a notable observation on Section 79 of the IT Act Section 79, known as the Safe Harbor Provision, protect intermediaries from liability for third-party information, data, or communication links available or hosted on their platform. In this judgment, the court clarified that safe harbor protection does not apply to child pornography. If an intermediary is informed by the government that any information, data, or communication link hosted by them is used to commit an offense, they must expeditiously remove or disable access. So, friends, this is something very important. The judgment, the landmark judgment of the Supreme Court, and the court directed the union government to constitute an expert committee to devise a comprehensive program for health, sex education, and POCSO awareness among children. The court has restored the criminal proceeding against Anil, whose trial before the fast track court in Truvallur, Tamil Nadu, will now continue. Thank you for watching this video, and this is what I have explained, and which is something very, very important for the children and the people who are addicted to use, child pornography and see pornography. Thank you very much. Jai Hind, Jai Bharat, and please keep watching this video till the end. Thank you very much.